To all participants, welcome. Thank you for your interest in our consent form wizard tool. We are glad, of course, to have you here. Hope you will enjoy this workshop and find this tool useful. For a start, let me briefly introduce our working group. So the working group on ethics and legality in the digital arts and humanities has been established with the aim to address the needs of the research and education community regarding the topics of legal issues and research ethics to help DARIAH with promoting open access of methods, data and tools, having in mind, of course, responsible conduct. We are trying to produce some clear legal and ethical recommendations, securing that research data, material and results will be shared and distributed as open as possible, and of course in accordance with all the regulation in European Union. We are offering some training and information material on intellectual property rights and open license, data protection and privacy, research ethics and scholarly conduct. And we are offering workshops to scholars in order to help them cope with these issues. So we established our group in 2017, and since today we have gathered more than 40 people from 18 countries, I think, in our working group, and we are covering a large variety of disciplinary fields. There are a few legal experts among us, but most of the members are just researchers or cultural heritage experts. We have conducted 2 projects since then, funded mainly through DARIAH-EU funding scheme for working group activities. The first one was in 2017-18. This one was called Open Licensing Ethics and Scholarly Conduct in Digital Humanities. And in the scope of that project, we produced actually a lot of recommendations, organized a lot of presentations and workshops, and promoted our working group through social networks and different digital platforms. And the second project, ELDAH Consent Wizard, started at the end of 2019. Has been funded through the same DARIAH scheme, but additionally supported by the CLARIAH Austria and DARIAH Croatia. And today we will present our main achievement of this project. So I think it is not necessary to present here some other details and activities. But we are also collaborating with other working groups in DARIAH and also with similar groups in other European research infrastructures, like Legal and Ethical Issue Committee of CLARIAH, the CESDA, Consortium of European Social Science Data Archives, the European Copyright Community, Icarus Ethical Board, Open Science Network Austria, and more. Because you are here with us today, I'm sure that you're aware of the importance of the issue of data protection and ethics in research. Internet and technical development made it possible to publish and disseminate data through the world. There is open science movement and also clear political drive in Europe to facilitate free and public access to cultural heritage and research data, primarily those hosted at publicly funded institutions. DARIAH also promotes open science and open access, but there is a lot of ethical dilemmas and legal obstacles related to this. In this age of digital information technology and the availability of information through the internet, we've become aware of some new circumstances. Now we have a technology and the possibility to put all material online on disposal to the whole world. And this makes our work far more complicated. For example, than a few decades ago, when books or archival material were kept in a physical form or on a paper, for example, hidden behind the walls and were not distributed so widely. In other words, before this time of online publications and the digital repositories, there was not so much risk of data misuse. it was a different situation back then, and the free use of data was implying something else. Researchers and publishers, of course, were following always the code of ethics, but they were not so burdened by legal regulations. So we are in a totally different position with this contemporary open access movement. Some new directives, recommendations, and laws have emerged to regulate the rights of individuals, and privacy and confidentiality become key ethical questions, especially in research projects involving human participants. And in humanities, private data are often very important for the quality of research. Sometimes it is important to know how old is your informant, is it male or female, what is his place of birth, ethnicity, and so on. And before the internet era, researchers didn't have a clue that collecting of those data could become ethically and legally questionable in some other context. So today we have a problem with such data and material collected a few decades ago, because we often don't have a right statement, a consent from human participants that will allow us to publish this old material online. Today, if we wish to conduct some research involving human participants, or we want to record or make photos at some social public event, if we want to collect email addresses so we could share our newsletters, we need to think in advance and get the consent from each human involved in our activities. Okay, I'm still here. Why data needs to be protected? Because of the ethical and legal reasons, obviously. Some of the ethical norms found in the guidelines for research ethics can also be found in the legislation. For example, the requirement of privacy and the consideration of human dignity. And if researchers don't follow the rules, they can bear the consequences. And that will happen not because they didn't follow the guidelines for research ethics, but because they have broken the law. What data needs to be protected? We are talking here about personal data like names, addresses, emails, but also pictures, voice recordings, and other sensitive personal data like racial or ethnic origin, political opinions, religious or philosophical beliefs, and so on. I'm sure Walter will talk more about this. Today, when a research project deals with those kind of data, researchers are obliged to inform the participants or subject of research and to obtain their consent. It is the same when you are organizing some event and want to make take a video or photo, for example, for future reports or publishing, or if you want to create a mailing list. So before it was all matter of research ethics, but today this is also a legal request. So you should be aware of that. So as much as the development of this modern digital technology brought to us a lot of improvements and new possibilities, on the other side, it made our work far more complicated. But in order to make our life easier, some digital humanists are developing the tools for scholars. So we have tools like similar to us, like CLARIAH license selector, or now you have this brand new Consent Form Wizard tool. So more about the tool you will hear later from Vanessa, but first I will give the floor to Walter, who will explain in more details those legal stuffs related with the GDPR and the personal data issues. So Walter, will you share your screen now, Walter?
Yeah.
Okay.
Okay. Yeah, let's jump right in. Obviously, the foundation of the whole thing and the reason why we are having this workshop is the GDPR. And in order to understand what the Consent Form Wizard actually does and does not, it's important to understand some of the terms in the General Data protection regulation, and that's why we are going to have a more precise look on the whole thing, obviously in very short order. So it's going to be a galloping through the GDPR. And if there are any further questions, of course, you can always get back to us. Now, the thing is that when the GDPR came, everyone was acting a little bit as if this was something completely new, which in fact it is not. For example, in the Charter of Fundamental Rights of the European Union, Article 8, and that has been around for a long time, actually they tell you about the protection of personal data. So everyone has the right to the protection of personal data, and such data must be processed fairly for specified purposes on the basis of consent, and so on and so on. And there are also some rights added here about the whole thing. And basically, that's kind of an abstract for the GDPR, really. So the whole thing has become a lot more regulated, a lot more detailed, but the protection of personal data has always been a very, very fundamental issue, both in national legislations and also in international treaties or contracts like the European Union contract. So nothing new, but in some terms it is new. Again, to just give you some context about terms that we are using on a regular basis here, I've put it here: regulation versus directive. You probably have heard about that oftentimes before, but still very briefly, the big difference between directives and regulations in EU legislation is that regulations actually become directly applicable European Union law, whereas directives first have to be implemented into the member states' national legislation. Now, also some of the stuff that is in the GDPR got implemented in national data protection acts, because especially when it comes to the exceptions, and like the research exception that we are going to talk about in about 10 minutes, these things have to be taken up by national law, and there are small minor differences in the application, or let's say in the scope of these exceptions in national data protection acts. If you want to have a detailed look at the GDPR, you can find it at these links. One of them is the European legal resource, the link below. You can also find it there in all European Union official languages, which may be quite helpful because these are the official translations if you're looking for specific terms and stuff like that. And there's also the website where you can look at the whole thing online in English, obviously, in this case. So the GDPR, as we know, it's enforced since 2016, and it has been applicable law since 2018, 25th of May. Now, what does it apply to? It applies to the processing of personal data, wholly or partly by automated means, and to the processing other than by automated means of personal data, which form part of a filing system. The only thing that is really important about this is that very often, especially in the digital world and in digital research, we think that data is always digital, which it isn't, obviously. So the GDPR, while a lot of it pertains to the digital world, it's not just about automated and digital means. For example, if you put you know, like attendance lists or exams or something like that by name into a folder, that is a filing system. And that means you're processing personal data. So you're processing the data of your students, for example, if you file away their written exams in a file system. What does it not apply to? It does not apply to data processing by natural persons in the course of a purely personal activity. For example, you take a selfie with your mobile phone and you send it by WhatsApp to your sister or your dad or your mom. That's a purely personal activity, so that's not a subject to the GDPR. What is also not subject to the GDPR is data processing by the authorities for the purposes of prevention, investigation, detection or prosecution of criminal offenses, and so on and so on. It has to be noted, obviously, that there are other regulations that are governing this. So there is nothing like a blank exemption for any, let's say, security processing. But there are exceptions to the GDPR for that and provisions to govern that. But very often these things are also dealt with in other legal texts. So it's not as if there was a blank exemption for authorities. What's processing? Processing means any operation or set of operations which is performed on personal data, whether or not by automated means. And the thing is, basically, this is the list of possible processing scenarios. And there's really everything in there: collection, recording, structuring, retrieval, use, disclosure, transmission, dissemination, but also erasure or destruction, which is very important. So if you delete something, you are still processing the data. And in order to be allowed to delete something, you have to be allowed to process it in the first place. So the go-to answer that you often got in the early days of the GDPR, that people said, oh yeah, okay, we may have personal data, but we're going to delete it right away, is actually a problem, because deletion is processing just as much as anything else. What is personal data? Personal means any information relating to an identified or identifiable natural person. An identifiable natural person is one that can be directly identified. For example, it could be the picture. It could be, if you are in a university system, your registration number and stuff like that. So identifiable is actually going very far. The GDPR does not apply to anonymized data. So if a person is not identifiable, it's not subject to the GDPR. However, keep in mind that anonymization has a very, very high threshold. So it means that by any means conceivable, the identity of that person cannot be recovered. So it has to really be a very, very high standard of anonymization in order to get you out of these obligations. So that's really a very high threshold to fulfill. There are 3 roles in the GDPR which are important to any means of the processing process. First one is the controller, which is the natural or legal person, can also be an authority, which determines the purposes and means of the processing. There is the processor, which may be a third party that processes data on behalf of the controller. A very popular example for that, for example, is that in a company, if you are an employee in many companies, the data controller will be your company as the legal person, but they may have someone else taking care of their personnel department, for example, and especially of paying wages and stuff like that. So they may have outsourced their data processing for these particular purposes to a processor that does it on behalf of the company, but the company is still the controller. And there is also the data subject, and that's all of us most of the time, because our data is processed all the time, and we as natural persons are the data subjects of these processings. And it's always important to keep in mind that we are very often in both of these roles. On one hand, especially as researchers, we are controllers to a certain extent, or processors, but we are also always data subjects in many processings that are happening at our research institutions, but of course also in our regular life. Now, there are certain principles of data processing which are governed in Article 5, and these principles have to be fulfilled in order to make processing of personal data lawful. So all of these have to be fulfilled. The short cap is lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. Now, some of these terms are fairly clear, but let's have a very brief look at what they actually mean. Lawfulness, and also lawfulness, fairness, and transparency actually means it can only happen with the consent of the person concerned, for example. Especially if you're processing sensitive data, then you need the express consent for that particular purpose. There could also be the compliance with legal obligations, for example, social security number or something like that, or the compliance with a contract. There is also the safeguarding of legitimate interests of the person responsible or a third party. If those interests do not outweigh, there is a typo in here. I have to change that slide for you, so we'll re-upload that again. But the thing is that there sometimes is, let's say, there has to be a balance between legitimate interests, and sometimes the legitimate interests of the controller may outweigh the legitimate interests of the data subject. And in that case, data can be processed even without explicit consent and stuff like that. There also has to be transparency, so information duties provided by the data controller, and data has to be processed in good faith, which you can find here. There's also a purpose limitation, so you're only allowed to process data for a clearly defined and legitimate purpose. You are supposed to do data minimization, so only collect the data that is necessary for that particular purpose of the processing. For example, if you register for this workshop, for example, we didn't ask you about your blood type, for example, because obviously that's not something that is a set of data that we need to process in order to make it possible for you to attend this workshop. Accuracy, data must be factually correct and up to date, so which leads us later to the rights of the data subject about having their data corrected. There is a storage limitation, so usually storage is only possible as necessary for the achievement of that purpose. There is a research exception for that, which we're going to look at in a couple of minutes. Integrity means, or security very often means, that there have to be appropriate technical or organizational measures. So on one hand, for example, if it's software or databases or stuff like that, there have to be special technical security measures. However, it might also come down to ethical security measures, or keeping records and documentations of what you're processing, and so on and so on. Accountability means that the data controller has to document what they are doing. They also need to train their people and give out information to their employees or to their and also to their data subject. But accountability is primarily also about documenting stuff and being responsible to, for example, the data protection offices that are responsible in your national legislation, so the surveying organizations. So these are the 7 principles of data processing, and that leads directly to the other side of the coin, and that's the rights of the data subject. And obviously that's the context that is kind of the important context for us also in this workshop, because if we're talking about processing the data of people for research purposes, we have to be aware of their rights, and we also have to be aware of the exception to those rights that are granted to us on the grounds that we are actually doing research. So the rights of the data subject are information. This information has to be given at the time of the data collection, so that's very important. Access, rectification, erasure or deletion, right to be forgotten, restriction of processing, data portability, and objection. What does that mean? The most important thing is the right to information, really. So at the time that we are collecting the data, we have to inform our data subjects about the processing purposes, the categories of personal data to be processed, the recipients, or actually categories of recipients that we are sharing the data with, especially if they are situated in third countries. If possible, the duration for which the personal data is supposed to be stored. The existence of a right to rectify or erase personal data, the existence of a right to appeal to a supervisory authority. That's very important. All of these informations have to be given at the time of the data collection. Now, that would actually pose many, many problems, especially if we are thinking about, for example, the right to appeal to, no, not the right to appeal, but the right to restrict the processing of personal data and so on, because obviously that would be a problem and put everything that we have done in our research in peril if suddenly our data subjects decide to remove their consent for that. So there are a couple of exceptions that are defined by the GDPR in Article 85 and Article 89 primarily for our particular scenarios, and that's why we should have heard about them, or that's why I should take note of them. On one hand, if you're processing for journalistic purposes or the purposes of academic, artistic, or literary expression, so that's very much about newspaper or journal articles, member states can provide exemptions if they are necessary to reconcile the right to the protection of personal data with the freedom of expression and information. So what has to be kept in mind is that there are certain, let's say, privileges in terms of freedom of expression and information, but on the other hand, they can only be taken if you also make sure that there is sufficient protection of personal data still guaranteed. And we see that in more detail in Article 89. So Article 89 says for archive, yeah, I'm kind of, okay, there should be a title up there. Article 89 says that there are, for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes, certain derogations or certain exemptions that the union or member state law can provide. Insofar as such rights are likely to render impossible or seriously impair the achievement of the specific purposes, as long as we are providing appropriate safeguards. Now, there's a lot of stuff in there, and that's something we have to briefly look at. Appropriate safeguards must be provided to the data subjects. What is that? That can be pseudonymization. That can be opt-out policies, signing a code of conduct, having stuff approved by an ethics commission, stuff like that. All of these are appropriate safeguards. And the consent form wizard is basically going exactly in that direction. The consent form wizard provides you with a safeguard by guiding you through this process. There are also several exemptions that we have, and we will touch on that as we go through the consent form wizard itself. On one hand, broad consent means that we can obtain consent not only for a specific purpose, but also for one or more research areas. which is an exemption to the to the principles that we were talking about before. There's also a purpose extension, which means that as long as you have collected data lawfully, research is always considered a compatible purpose with the original purpose of the data collection. There is a storage, we have heard about the storage limitation. There is no limitation for the duration of research data storage as long as it's necessary for the purpose, and especially not so much research, but also archiving in the public interest, obviously, is something that, whoops, that was too quick. Archiving in the public interest is obviously something that rarely has a limitation, a storage limitation, because public archives want to store their data infinitely, ideally at least. And there's also, and that's very important, a exception to the right of the data subject to restrict the processing or object to the processing, because that objection or that restriction is not applicable if the exercise of that right, as it says here, is likely to render impossible or seriously impair the achievement of the purpose of the research. So if you conduct a study, and we're going to look at that in a few minutes now, if you're conducting a study and processing personal data for that study, and it would render your research results and study results unusable, essentially, if this right to the restriction of the processing is exercised by your data subjects. You can basically protect yourself from that claim on the grounds of Article 89. And all of, like, Article 89, for example, in Austria has been introduced in the Data Protection Act, the Austrian Data Protection Act, the national legislation, as paragraph 7. So you will find it at different places in your national legislations, but you will find them in your national legislations as well. That's a good thing. To see how all of this ends up in practice, what we have to consider and what we can basically use for our purposes in that respect, we will now look at, and I'll hand over to Vanessa to give you a more detailed look of the Consent Form Wizard and how the Consent Form Wizard applies all of these principles and rights that we have seen in practice.
Thank you very much. Hi, everyone. Also from my side, it's very strange to jump in and say the first thing that you say after like 45 minutes into a workshop. So welcome also from my side, 45 minutes later. Nice to have you all here. I will share my screen with you so that we can jointly look at the wizard. Yes, so you heard quite a few things about ELDAH and why ELDAH is a good idea, and what it is that we do in the context of ELDAH, and that data privacy is one of the issues that we found out that we have to concern ourselves with. You also found out how complex the European data privacy legislation is, and what all the aspects are that we have to consider when we try to comply with this European data privacy legislation, namely the GDPR. And in the course of all of this, while Walter was talking, you probably realized that if you don't spend a significant percentage of your working hours with reading and interpreting the GDPR the way that we do, then you will, in all likelihood, forget some of its aspects when you have to consider it in practice. That is a problem that not only you have, but many researchers have, because we very usually are not lawyers, at least also Walter and I who were also involved in implementing this tool are not lawyers. And so you will, in all likelihood, need some support. And so that's how we came up with the wizard, because a wizard is always a good person to consult if you need some help, right? So we came up with this tool, which we developed, so as I said, Walter and I are not lawyers, but we did develop it working together with a lawyer. So don't worry, we asked someone who knows their stuff if we considered everything, and he said that we did. He's here, by the way. Let me say hi to Pavel Kamotsky, who is the lawyer who consulted and developed this tool together with us. And another person who is not here is Norbert Zirjak, who is the programmer who implemented the tool for us. And is continuing to implement it when we find bugs, which we do at pretty much every workshop that we do about the wizard. So it's very much, you know, learning on the job, developing by using kind of tool. So that's all my introduction to how we came up with the consent form wizard. So you're looking at it now. What is the consent form wizard? So as we said, as a researcher, you are most likely to come in the realms of the GDPR at some point in your researcher life because of various classical reasons that we identified. So the three most typical situations that you as a researcher will find yourself in that will require you to consider the GDPR and maybe collect the consent of data subjects will be, on the one hand, when you collect data from living people for research purposes, when you are trying to set up a mailing list to inform people or keep in touch with other researchers, or when you organize an academic event, which at the moment will in all likelihood be happening online or be very small. So these are three main scenarios that we identified that you will likely have to tackle in the course of your researcher life. And to help you in doing so, we developed the wizard. So the wizard is basically a questionnaire, not to your research subjects, but to you as someone who has research subjects or mailing list participants or event participants. So you are being asked what kind of data you're planning to collect, for what purposes you're going to do that, and so on and so on. So that's the questionnaire that you have to go through. And then after you will have answered all our questions, the wizard will process whatever information you provided and provide you with a template for a consent form that you can hand over to your data subjects for them to consent to. So that's what the wizard does. It basically provides you with a ready-made consent form that you can use. What I have to mention before we go in and look at the scenarios, look at the questions that are being asked in the scenarios. One thing I have to mention before, so that's the classical disclaimer. Whatever result you get is very much dependent on the input that you give naturally. So we cannot check if you are lying to the wizard. For that reason, we can also not be accountable for whatever output that you generate by using the wizard, because if you go in there and say, oh, wizard, yes, my name is Harry Potter and my data protection officer lives in Hogwarts, then that is up to you, and we cannot control, since you know, you are the master of your own personal data, and it's up to you to provide them or not. But if you enter this kind of data into the wizard, then obviously the consent form that it will spit out for you in the end will be semi-usable, let's say. Also, I'm not sure if the GDPR applies in Hogwarts, but that's probably a different issue. So what I'm trying to say is the wizard will ask you questions that you might find a little tedious, some of them maybe, and it will even make you run into dead ends if you give certain answers. You can work around that by giving different answers and de facto lying about what you're planning to do. That's up to you. You will end up with a useful, valid consent form. But of course, if you lie, then the consent form will not cover what you're actually planning to do. If you do run into a dead end in the wizard, then that can mean that either what you're trying to do is too legally complex to be answered in a still relatively simple tool such as the wizard, or it can mean that you're planning to do something illegal. The wizard will inform you that that is what you're trying to do if you are going to act the way that you answered the questions. Everything you do from there on in is not our responsibility. Technically, also everything that you do up until then is not our responsibility. So this is a tool that is supposed to support you, supposed to help you. We are also here to start discourse with you if you have an issue that you feel you need input in, but we are not legally responsible for any sort of outcome that the wizard provides you for the various reasons that I just explained. Before we start to look into the scenarios, which we will do in the breakout sessions, I have to mention two more things. One thing is that you can see that we have the last official update. So we try to provide like official dates when we last updated the content or the structure of the wizard, simply for the reason that legislation sometimes changes, and you will need to know if the latest changes or court rulings in the area of data privacy were considered or not. So that's why it's important to provide a last update information date. You can see that for now we have September 22nd, and it used to be July 15th, and it used to be July 15th for a very practical reason. On July 16th, the European court decided that the Privacy Shield deal that the EU had with the US would be rendered invalid. So there is currently no valid data privacy deal between America and the European Union, which makes data sharing with any partners in the US somewhat problematic. That is a problem that we are not able to fix. That is a problem that the EU can fix and that the EU will have to fix. Up until it will be fixed, the wizard will not provide very useful answers in this area. That's just that's unfortunate, but that's what the situation currently is. So be aware that if there will be another ruling or another change to legislation, then the wizard will, we will of course strive to always keep it up to date, but this can be, you know, when we cannot adjust the entire tool immediately after every court ruling, or it could happen that we don't find the time or possibility to do that. So in that case, then the tool would of course not be able to consider all aspects of current currently valid legislation for just, practical reasons. Also, one more thing, the wizard, by using it, you will provide personal data, and we, by collecting these data and processing them for providing your consent form, will be processing your personal data, which is something that you, as you learned today, have to consent to, which you do. And this is the last thing that it says here, right above the big word enter, which you do by clicking on this word enter. So by clicking onto that, you agree to the processing of your data for the purposes of the functionality of this tool. However, your data is not being stored, or at least shouldn't be. There is a strange bug at the moment, which we are about to fix. So yes, that's all my introduction that I have to the wizard. So when you click enter, you land on the start page, or on the, you end up with the first question that you have to answer. And this is hopefully a relatively simple question. It's what are you planning to do? And when preparing this workshop, we split you up in 3 groups, and for the purposes of testing the tool and working on the tool with you and answering your questions, we assigned you with plans. So we decided who of you was going to plan to gather data, to communicate through mailing lists, and to host an academic event. So the next thing that we are up to is we will split you into these 3 groups and send you out into the breakout rooms, where you will have, I guess, roughly 20 minutes to go through the scenario that you have been assigned, discuss it with everyone else in the breakout room, and one of us will be in there as well to answer your questions and collect your feedback, and to explain maybe one or the other specificity of the scenario that you were assigned. So yes, that's it for my intro to the wizard. Okay, so now that we are all back, maybe we can do a very quick wrap up of what we learned in the sessions. I think if it's okay with everyone, I will start, and I will say that I think maybe the another, because whenever we do these workshops, what we take away is a to-do for ourselves, one more thing to implement in the wizard. And I think very useful remark that we had was it would be useful to inform people about when they don't have to collect consent, because as we discussed earlier today, there are other legal bases for data processing, and it would probably be very useful, because the wizard makes it seem or maybe to some makes it seem that you have to collect consent for absolutely everything that you do, but you don't, because there are other possible legal bases for data processing. So a useful remark to add somewhere at the start would be, if you are processing data on the basis of the fulfillment of a contract, or help me with other legal basis, a legitimate interest, then you don't have to generate a consent form and collect your user's consent. So that is, I think, something we can basically, we can easily solve by adding 1 or 2 sentences to the start page of the wizard. So that's easy to do, and I think it would be quite beneficial for our users. So I think that's something we should do. So that's the news that I brought. How about the 2 of you?
Yeah, I think there wasn't really much hassle. Basically, we were just talking briefly about legitimate interest about the term, basically. When is a purpose more legitimate than the other? So it's kind of it's to talk about this balancing, I think, is actually important. And otherwise, I think things went pretty well. There was a short question about the sharing data with people outside of your institution and so on, but I think that has been cleared up.
Yes, we also didn't have much time for a discussion, and but we didn't find any problems actually, because we had this easiest scenario for communication through mailing list. Actually, the only one question comes about contact email on the first page of this scenario for the communication channels, because contact email, whether this is a person or the formal institutional email address, like, you know, info@ or contact@ the institution, or it's a personal. But since we have a data protection officer as a separate, as additional possibility to add, I think that this contact email is a person who is organizing, who is leading the newsletter or communication channels for the institution, and the data protection officer is this official email address, actually, if somebody needs for that purposes. Yeah, and I asked the participants to put the emails in the chat if they have any kind of additional questions or needs, or if they have any other ideas about possible future scenarios for the development of our tool. I told them they're welcome to get in contact with us and propose whatever they want to us.
Yes, that is actually a good remark to start sharing my screen again. Yes, do get in touch or stay in touch. You can do so by any channel you see fit. You can, you know, poke us on Twitter, though we keep losing our password, so you can contact us on Twitter, but you'll probably get a quicker answer if you email us. Realistically speaking, so we do come up with a new password like every 3 months or so. But yes, the Twitter account is let's say somewhat active. We also have a YouTube channel where we put videos of various things. We do very much encourage you to join our mailing list, because then you will receive the also somewhat regular ELDAH newsletter that informs you about all the very cool things that we do and all the events that we're in, such as this one. So that's also something you should absolutely be on. So I'm in the advertisement section now, as you can see. If you want to contact us with questions, remarks, issues, you can email us at ELDAH@DARIAH.eu, and you can also follow updates on all the stuff that we do and all the new developments of the wizard, etc. on our blog. And speaking of the wizard, use the wizard, consent.dariah.eu. That's the place to go.